Welcome. Today I have a fantastic guest. I have my guest is Kamyar Maserrat. He is an intellectual property lawyer, expert in deep technology such as artificial intelligence, robotics, and quantum technology. He's a senior counsel at Foley Lardner. Welcome, Kamyar. Thanks for being my guest for this episode.
Thank you for having me.
It's a great pleasure because having your view on this fascinating world of deep tech is fantastic. Is precious because once again we have in this podcast the view of scientist and an engineer, but having your point of view as an IP lawyer is very precious because you see things differently. You see it at an age that the engineer who who are focused on their field, they can't see. So what you can bring them is very precious. So thanks again, and I think we'll have a great moment together.
Thank you. Yeah, I will talk about my background, but I'm an engineer. But now I play. I'm still an engineer, just from a different point of view.
We'll talk about that in a few moments. But just let me introduce the driver of the episode. If you agree, we will talk about a little bit about yourself. About your background, and then maybe you can explain us the word of IP because it's very complicated. It seems complicated, but maybe you can tell us that it's not, and how we can view IP in a more strategic way with the business of a startup or of any inventor, in fact. And then maybe we can discuss a little bit about the emergence of IP, artificial intelligence, and how do you evaluate them for patenting, because it's very complicated. We have true artificial intelligence. We have people who are connected to OpenAI model and other models, but through API. Are they artificial intelligence or not? There are so many questions on that space. What do you think about the plan?
That's great. Fantastic.
Okay. Fantastic. So where are you from and where you grow? What was your childhood environment? Were your parents lawyer, entrepreneurs, engineer too? And how did you end up studying law?
Sure. So I was born and I grew up mostly in Iran, in Tehran. My mom was a school teacher, and my dad is an engineer. So my brother, my sister, and myself are all engineers. I don't know if they somehow tricked us as we were just growing up and they just planted the idea, but they successfully pushed all of us towards being an engineer. There's a funny joke that a lot of people say when you're an Iranian, there's three options for you. There's doctor, engineer, or the failure, right? So I chose the first one. But I was born and I grew up in Iran. I moved here to the States after I finished my 10th grade. So I actually did a lot of schooling in Iran. 10th grade, moved to Texas.
But because as we have many difference between the school system from Europe and America, the 10th, what age? Tell me about age because it's more easy.
Sure, absolutely. I forget that a lot of people who are watching this are from Europe or are in Europe. So I was 16 and a half.
Oh, okay.
So usually in the at least the Iranian school system, and I think that corresponds to the American school system, you get a diploma after 12th grade. And I finished 10, so I had 2 more years to get my high school diploma. So 16 and a half-ish, started 11th grade. And so I did 2 years of high school in Texas before I got my high school diploma.
And how was the life in Texas?
It was very interesting. I grew up in Tehran, which I'm sure you're aware is the capital of Iran. It's a big city. It's very congested, and there's high traffic and loud noises. It's very much like any other metropolitan area. New York, Paris. There's a lot of people. And we moved to Texas because we have some relatives there. So that's, I guess, if you're an immigrant, that's how you pick a place. When you know someone who's there, you just go there. So it was a suburb of Dallas, actually. So it was very quiet. I don't think I've ever in my life ever experienced that level of quiet. There's no traffic, big houses. We lived in a flat in Tehran, but in Texas, the stereotype really holds up. 6-bedroom house, big backyard. There's a pool in the back. And I'm like looking around. The neighbor is an acre away. It was very, very different. But my high school experience was actually not bad. I enjoyed it. I was lucky enough because my mom was a teacher, so she she was very adamant about me learning English. So at least I had that advantage, and I could connect. I could hit the ground running, as we say here. When I started 11th grade here in the States. I'm no longer in Texas, but here in States.
And I imagine that as your father was also an engineer, he helped you a lot with mathematics and physics.
Yeah. So there's a running joke that they did some sort of an inception, like the movie. They kind of like went in our dreams. And my sister does. She has 2 masters in computer science, and she's in tech. My brother the same way. So he certainly helped guide that overall view, the mathematical, scientific view of the world that I have. And it was funny because after a few years, when I decided to go to law, he was not exactly the happiest person. He was saying, well, engineering is not bad. Well, I don't understand why you need to go to law. He's okay with it now, so that's good. But yeah, no, he helped. And after high school, I went to University of Texas at Arlington, and I studied engineering. So I studied civil engineering with a minor in computer science. That was an interesting time. Looking back, in hindsight, I probably should have just studied computer science and not just minored in it, because what I do now is 90% in the realm of computer science. But civil engineering was also fun. A lot of the principles, scientific principles are the same. It was an easy transition for me to move forward with that. So once I finished my undergraduate degree, I started practicing engineering in Dallas for about 4 or 5 years. So I actually practiced engineering before moving on.
And so you were a civil engiiner?
Yeah, I was a civil engineer
by experience. Because I when I see you, I see a lawyer. I see a lawyer pleading in court. But you are a solid engineer working on to build bridge and road and stuff like that, right?
Yeah, no, we at the time we actually designed Parkland Hospital. Boy, I never thought I would. I haven't said those words in at least 10 years, maybe even more. We designed Parkland Hospital, which was at the time one of the biggest hospitals in the United States. It was in Dallas. And we designed all that stuff. Now, because I was I still had my interest and my minor in computer science. So I always liked coding. I played around with that stuff. But a lot of civil engineering now is knowing how to model bridges or building or whatever the structure is in a way that actually enables you to analyze it, like a digital twin, as they say. Nobody said it back then, but now you create a digital twin of it in the virtual world, and then you get to play around with it, simulate what happens if there's an earthquake, if there's a tornado, if the wind blows. So still a lot of computer aspect, but yes, I designed buildings and bridges.
Wow, fantastic! And what happened to you to decide? Well, now I want to become a lawyer and going to a law school. And what was it? An accident? Did you have a car accident, something like that? What happened?
So I fell and hit my head and decided to just work more. No, I wanted to do more. I think after 4 or 5 years of engineering practice, there was a steep learning curve in the beginning, and it was very enjoyable. But after 3-4 years, I knew I wanted to do something more. I knew I wanted to do something and still at least even adjacent to engineering. So something associated with engineering, with science. So I looked into different options, actually. I thought about, I started graduate school. If anyone of your listeners know where Southern Methodist University is, probably not, but that's SMU as another school in Dallas. I started there. I thought about doing an MBA and maybe doing some startup work. My sister was always in the computer science world, so we're very close, compared ideas. I knew I was going to end up in patents if I went to law school, but I resisted that quite a bit. I wanted to experience other types of law. So I started law school at Texas A&M, University School of Law in Dallas. And I did that at night while still working full time as an engineer at the firm in Dallas. So I knew I didn't want to just go directly into patent. So I wanted to practice other types of law. I interned at a family law firm. I interned at a personal injury law firm. I got that experience, and I kind of sort of got it out of my system, quote unquote, before I settled on patent law. I think all sorts of law practices are interesting and respectable. I just think I want to be around the scientific community, and that's just what interests me more.
And in fact, what you have done is very smart, because starting by other type of law, family law, and so on, will push you to to train yourself to plead in court, because there are much more opportunity to do that than pleading for patent, and the technicity of pleading is more punchy in a family court and so on.
Absolutely, it's definitely a lot more punchy. Yeah, it's a lot less drama in the patent world and in the technology world than it is in family law. I have some interesting stories that shall remain unsaid, but it certainly helped. It certainly helped me shape my interest, and now that I'm in patent law, I never really think about any other type of law.
We have a comment or question by Ali Malihi. Kamran, we are trying to bring efficiency into the freedom to operate and prior art declaration. We believe we can do this if you create an artificial intelligence and blockchain enabled data defined network where we can track and trace data and ownership. Try to read because it's small.
Yeah,
and activity
for me it's cut off actually.
And much more granular basis than is being done today. Any idea? Wow.
Yes. So okay. So let's start from the top. Freedom to operate and prior art declaration. When you say prior art declaration, you mean identification of prior art, and we'll talk about the IP side. But since this question came up, we'll talk about it now. I think there are certainly other companies in this space now that are using. So before, let me tell you what prior art is. And we'll get into the patent talk, but since this question came up now, when you file a patent application, it certainly has to be novel, right? And every jurisdiction that I've ever heard of has to be at least novel and unobvious in light of what is out there already. So that is what the word prior art is colloquially referring to. So I think what he's saying is they're using AI and blockchain-enabled data-defined network where you can track and trace data and ownership and activity lineage and provenance at a much granular basis. I think that's a great idea. Is that being done today? I don't know if that's being done for prior art purposes, but certainly AI-enabled prior art search is out there. AI-enabled patent analytics tools are out there. I don't really know how much blockchain can help. Blockchain is fantastic technology. It is immutable. That's the best part about it. So you can track things without anyone, at least in theory. We'll talk about quantum, but at least in theory, nobody can mess with it. Yes, for research. Okay, yeah. So I don't. A lot of prior art, at least, is already in public domain. So I'm not sure if blockchain would help. It certainly doesn't hurt, but I don't know if there's a necessity for blockchain. But certainly we can talk offline if Ali, if you're interested.
So blockchain is the best way you can create the smart contract.
That's very true. It's the best way.
So you finish your law school. You swear at the bar, so you can official lawyer. You may cry your parents because you
I disappointed my parents. Yes.
And so, yeah, sure. Please. Yes.
After law school, I got recruited by IBM, and it was very lucrative to me because IBM files at the time. So this was 2014. IBM at the time filed the most patents in the world, and it had that record for, I believe, 20 or 21 years prior to 2014. I think they have shifted since, and they no longer want to be the patent leader in the world. I think Samsung is number 2 now, or they used to be number 2 and now probably number 1. Anyways, it was very, very interesting to me because IBM is a big corporation and they recruited a team out of various law schools. I think it was 20 or 21 patent attorneys to work on their project. So I moved to New York from Texas, also a big change. And I started working at IBM as a patent attorney. They trained me, which was fantastic.
Wow.
It's a big giant tech company. It's one of the oldest tech companies, if not the oldest. They know a thing or two about tech and how to pivot, how to navigate those trenches. They've seen it all as far as tech is concerned. So about week 2, they gave me 2 options. They said you have 2 options. You can work with the chip design team, which is exactly what it sounds like. The team that designs chips. So you can write patents for that team. Or we have a new division called Watson. And Watson, at the time I didn't know, but Watson was one of the first AI models it was definitely the first at IBM, which was the first sometime in the world, one of the first. And it was their flagship AI model and AI team. And they said, we're developing this thing together. If you want, it's probably going to be a little bit more challenging, but we'll teach you whatever you need to know and you'll get into that. So I was always interested in more of a cutting edge technology. Nothing against chips, but they've existed for a few years before I started doing patents. So I joined the Watson team. Just looking back, it was almost pure an accident. I just thought, oh, this is cool. Why don't I see what this AI thing is about? That was 2014 that I joined the team.
Do they already call what they were working on artificial intelligence, or even they were seeking to name what they were doing?
Yeah, so they called it big data analytics.
Okay.
But then very shortly after, they said artificial intelligence. Now, looking back now, they were actually working on what is now called a language model. So it was not a large language model. It was not a transformer. It was not the same way because GPT works in a fundamentally different way, but it's the same kind of result. And they called it big data analytics when it came to predictions, and they called it a language model, just the LM, I guess. But yeah, they were calling it AI at the time.
Fascinating. It's just fascinating to see how luck in life, you can completely drive your fate,
Right.
And because they could have proposed you the chips and I don't know, packaging. They propose you the chips and something completely crazy and new, and you choose the thing that was completely new and crazy.
Yeah, it was absolutely. It was definitely a little bit more challenging to join a team that was brand new. At least the patent portion was brand new. The engineering team was there before us. But yeah, no, it certainly worked out. It's pure luck.
Wow. And during how many times do you work with the Watson team?
So I was at IBM for about 2 years, and I would say there was maybe a 2 or 3 month training period where they kind of teach you about just general ideas about neural networks, and this is what we're trying to do, and this is what training a model means and stuff. So I would say about a year and 7-8 months out of the 2 year. So most of it.
Wow. And then you quit IBM to become
yeah. So what happens to a lot of people where they're in-house, as we say, so they work for these big tech companies, is that the private sector knows that a thing or two about that technology. So they really just recruit you to the private sector. So this happens quite a bit. After a couple of years, I thought it was time to try something a little bit more than just one sector. Private practice, which where I am right now, has advantages and has disadvantages. One of the main advantages is that you get to work with different clients. So working with Watson was fantastic. I learned a lot, and if I could go back, I would do it again. But it was just one client doing one sort of technology. In private practice, you have a multitude of clients, and they do different things. They do it different ways. So you get exposure to different types of, even within AI, you get exposure to different projects. You also get exposure to other things, as in There are other parts of intellectual property that I was interested in. Freedom to operate, for example, that Ali was mentioning. There are, more than just prepping and prosecuting patent applications. There was some trademark, there's some trade secret work, there's some litigation work. I mean, once you have the patent, if you're in-house, you get patents. That's fantastic. But then you just kind of sort of hand it to them and you're done and you move on to the next one. As someone in private practice, sometimes your clients come to you and they say, we already have this patent and our competitor is doing this. So why don't you go negotiate with them and make sure they're no longer infringing? We can sue them. So after 2 years of IBM, I joined a law firm called Dentons, which is at the time it was the largest law firm in the world. I don't know if they still are, but after 3-4 years, our entire team moved to a new firm, which is Foley Lardner, and I feel like I'm finally settled to where I want to stay long term.
Fantastic, and working as a private in a private law agency consulting firm is great, because intellectually it's really stimulating you to see different clients, different technology, different state of their development. Sometimes you have a startup, sometimes you have a scale up, sometimes you have an established big company, and the different challenge and problematics, and this is great. Okay, so we have a great view of how you become a strong IP lawyer. So now maybe you can explain us this word, because for most scientists and engineers, it's they are not trained during their education. Sadly, this is also a discussion I have with the friends who is IP lawyer in Europe, that both in scientific education or engineering school, we don't have so much information about IP, what is a shame, because it's very important. Maybe you can help us to understand a little bit better.
Absolutely. Yeah, it's as part of what I do, I present this information to a lot of clients, because most engineers, they're not exposed to this side. We both have scientific background, so most of the time they teach you science and then they really just move on to another scientific factor. They never talk about the business aspect of things. They never really talk about the legal aspect. So really, intellectual property is when you have a scientific discovery or an innovation, or really anything that you want to protect to distinguish yourself from your competitor. You can use intellectual property laws, and there's US laws and there's European law. Every country has their own laws, but they're generally the same concepts, even though there's small differences in different jurisdictions. So it really allows you to protect your innovations, whether it's in software, whether it's in other types of innovations. It allows you to protect your know-how and gain that competitive advantage over your competitors. So when we say IP, there's usually different major types. So there's patent, which is predominantly what I do. Patents really protect invention that are new, they're novel, they're useful, they're non-obvious. And when I say invention, that really, a lot of people think of like an old tangible thing, but it's really anything. It's processes can be protected, machines. If you're in the biospace, certain compositions of matters can be protected. If you're in the software space, software can also be protected, even though there's a big caveat there. So a patent grants exclusive rights for you, the inventor, or the assignee, or the owner of the patent, for a limited time, which is about 20 years after you file it, to exclude others from practicing your invention, from importing any machine, from even using it. So it's a very broad protection. So let's say you have a patent on X component that goes into this watch, which is imported from France, actually. You can stop this company from importing, or any company from importing that patented technology, or stop them from using it. So it doesn't matter that this thing is going to be a part of a different product, and that company has never heard of it, even though there are many caveats here, but I'm really oversimplifying this concept. But you can basically say, I own this invention and I want to be the only one who uses it. And if you want, you can stop theoretically anybody from doing that. And that patent is a very powerful tool to stop others from using it, importing it, even offering it for sale. So that's patents. That's one category. There's also copyrights, which protects original works of art. or authorship. Copyright is the best example, is the book you write, but it also applies to software coding. But I'm not talking about the utility of the software code. I'm talking the actual code. The protection is about, I think so is the life of whoever created it plus 70 years. Best example is the way Mickey Mouse looks. Walt Disney created that character, that Mickey Mouse. So if you want to draw Mickey Mouse, you're going to infringe on their property because they worked on it, they developed it. A writer's character, all these shows that you see, they're copyrighted. So then that's the second category. The third category is trademark. Trademark is basically protecting your brand identifiers. Now, the brand identifier can be anything, really. It can be your name of your business. It can be the name of your podcast, for example. It can be a logo. It can be a slogan. It can sometimes even be color. So, for example, the Tiffany blue, the jewelry, that really you see that distinct blue and you think, oh, this is from Tiffany. You don't think this is from Walmart, even though Walmart is also blue. Walmart is a very different store for all the European participants of this podcast. I'm not sure if Walmart exists in Europe.
No, but we know we know what Walmart is because it's so big and so famous. So everybody knows.
Right. So really anything you use to distinguish your business or your product from others. The tick for Nike or the golden arch M for McDonald's, those are their visual logos, but Just Do It is also a distinguisher. So it's not necessarily just a name. So that's the third category. And the last one is actually the most important one, most interesting one, sorry, not most important one, but it's the one that's the least talked about, and it's trade secret. Sure. Right. So that trade secrets, they really protect your confidential business information and know-how. Ironically, you can't just keep it a secret and expect it to be a trade secret. You have to designate it as a trade secret. The best example for trade secret, which theoretically can last forever as long as you keep it a properly kept secret, is the formula for Coke. Sure. So no one really knows and what the actual secret sauce for Coke is, even though Pepsi will try, and then Coke will try to figure out what Pepsi's doing. But that formula is not necessarily known to anybody outside Coke. And you have to actually go through various steps to make sure that it's kept as a secret. It has to be designated as a secret. In today's world, everything is in databases. So it has to be walled off from other people. Google's search algorithm is another example of something that's a trade secret. So when we say IP, we generally mean these four categories, even though there are other subcategories, patents, they're provisional, non-provisional. There's the PCT, which is the Paris Convention Treaty. There's the design application. There's utility application, obviously. And then there is even plant applications. But those four things are the overall arching protections that you get.
We have a question by Ali, and I will ask you my own question just after.
Yeah.
So, Ali is asking, are there firms working on breaking patents to small bytes and pieces for licensing efficiency, narrow cast licensing?
Those are very good questions. Yes. I don't know if you can break a patent into small bits, but you can certainly write them from the very beginning into what we call a thinly sliced patent. And let me tell you what that means. So the short answer to you is yes. So let's say there's an innovation, you have a software innovation, and you want to patent it. And intellectual property is very much like a real property, in a sense that you have to protect it. In real property, you put a fence around your land. In intellectual property, you write a claim that identifies the metes and bounds of your invention. And if you think about the fence, sometimes you have a fence around a few big posts, and sometimes you have a fence around more frequent posts, but they're smaller posts. So it's really not a one-size-fits-all approach. It really just depends on what the invention is. So sometimes, Ali, yes, you do break it down into smaller posts that are frequent. So one innovation or one product can be covered in 4 different patents. And then the advantage to that is exactly what you mentioned. You can license them separately. You can monetize them separately. So you can sell one and keep another one. You can bundle them together. IBM does a lot of this. You can bundle them together, and that will give you some advantage as well. So that's the long version of the short version. That was yes.
I would like to propose you a kind of intellectual exercise. Just imagine that pencil doesn't exist. This is an 101 example, that most IP teacher use is the pencil. So I came to you and say, hey, I invented this great pencil. It's with wood, and there is I don't know how we sell it in English, to the
Lead.
Exactly. And there is another guy say, okay, so I want to patent that. And then once I have the patent with the claim, another guy come and say, I want to put an eraser on this thing that is already patented to someone else. How can I do it, and how can I exploit it and do business with my invention?
That's a very good question. And so one of the conditions for patenting something is it's novelty, obviously, but it's not just novelty. It also has to be non-obvious in light of what is out there, prior art, as Ali called it earlier. So a pencil existed, maybe it's already patented, but nobody really thought about putting the eraser on top of it. The patent can be drafted as in, there's a cylinder, there's, wooden material that's compact that surrounds or engulfs a lead cylinder within the pencil, or I guess if pencil does not exist, we don't know how to call it, but there's a cylinder of wood. Within it is a compact wood, and then inside it, that shaft is a piece of lead, and then that can be cut so you can write with it. We would write the patent as in, okay, now there's an eraser, and then it goes on top, and this is how it goes. Some embodiments would go in a different place on the side, for example. And then the patent office will probably come back, and their job is to push back. And the job is to say, well, eraser already existed.
Hope you can.
I can hear you.
Okay, so we were stopped at where we are knocking at the door of the patent office.
Oh yeah, so the patent office their job is to push back. Their job is to say, well, eraser existed, pencil existed. It's obvious for someone to put that together. And a patent attorney or an IP attorney, their job is to say, well, this is not really a combination that's obvious in light of what existed before. Now, a more realistic approach to that example, because the pencil example is a little bit oversimplified. So would be, you have a chair and there's 4 legs. Well, I want to add a 5th one. Can I patent that? Well, if it worked with 4, it's going to work with 5. So the utility hasn't really changed. You're really just changing the ornamental value. The same thing with pencil applies, but in the pencil case, you're really changing the utility. So there's really no single answer. It was just more of an argument. There are factors that the patent office or the patent attorney can argue. Is this something that was done before? Well, if it was that obvious for everybody to do, how come it didn't exist it did not exist before? How come nobody put an eraser on a pencil if it was that obvious, patent office? How come it doesn't exist? I think Ali has another question. But, in chemistry, there's a lot of, in the biochem space, there's a lot of that. Is it an experiment that was never done before? Sometimes you can find literature that is from that industry that actually talk about how this thing is not possible or it's very hard to do. That kind of stuff strengthens your argument of non-obvious.
Just before I read the question of Ali, I would like to follow up with my pencil. So imagine the patent office accept the patent for the eraser on the pencil, but the pencil is already patented by someone else, just for the pen, for the pencil. Mm-hmm. How does the guy who invented the eraser on the pencil can do business by not infringing the first patent?
The pencil has already been, okay, so you can write the claim, so when you patent something, the claim is really what defines your invention. So you can write the claim of the invention, and this is really where a good patent attorney is distinguished from a regular or a bad patent. You can write the claim and define the invention in terms of the pencil. That's a bad idea, because you need a pencil for that thing to be on top of it. And if your definition of the invention includes the pencil, then that means you have to go get somebody who does the pencil or has the pencil. But you can define the eraser on its own terms. So you just say, instead of saying it's an eraser on top of a pencil, you can say we have a cylinder that has an area that's emptied out and is configured to receive a pencil. And it has, on the other side, it has an eraser. So if you bring up your pencil, that little yellow part is what I would claim. So I would claim that, not the eraser, not the pencil. I would claim the yellow thing, because the owner of the pencil doesn't really matter if you own the pencil. You're going to go need that yellow part to connect the eraser to it. And then you would go approach the guy who owns the pencil or owns the IP for the pencil and say, if you're ever going to put an eraser on your pencil, you're going to need that yellow little thing. And you better pay me a little bit of money, maybe 10 cents for every dollar, whatever the negotiated price is. And every time you put a pencil or you put anything in it to connect the eraser, then that's where my IP comes in. So I love that example that you just asked, because that's a good example of how you can define your invention that can be on its own as opposed to be connected to something. And this comes into place with a lot of software, right? A lot of software needs data. Data has to be queried from somebody else. Well, you did not invent querying the data. So if you define it as in the terms of querying, that's not really going to help. In patent office, at least in US jurisdiction, we call it divided infringement. I'm sure Europe has it. I don't know what they call it. But divided infringement means if you need two different parties to do something for them to combine their forces and infringe your patent. So let's say your patent, and it's a software patent, has steps A, B, and C. You want to try to write all those steps A, B, and C so that they're all performed by the same person or same entity. If A and B are performed by entity A, and then C is performed by entity B, you can't go sue entity A, because A is going to say, hey, your invention is ABC. I'm only doing A and B. So you have to then bring in both entities, or it's not very valuable. So these are very nuanced approaches. Hello?
Oh yeah, I hear, but
You can hear me? Yeah. So these are very nuanced approaches. But I love that pencil example. I'm going to steal it.
Yeah, sure.
Use it from now.
It's a great example because it offered the opportunity to talk about not infringement, but also deal negotiation. You have your eraser and you knock at the door of the one who has the patent of the pencil and say, maybe we can do something together. So it's also the purpose of business, not just to fight each other.
Right. No, absolutely. And it's important. It's really an art of defining the invention in a way that maximizes the potential for the inventor to be able to negotiate that.
So Ali, as a VC, I see many scientists rush to fill patents, whereas we would recommend to them to stay with trade secret and run fast and keep their powder dry for later patenting as their business matures. What is your advice?
Very good question. So in real life, I think patents are used for more than just figuring out who's doing it and then suing them for infringement. It's a very costly process to actually go through that. You have to prove that they're actually doing whatever you're claiming. A lot of people, a lot of companies, a lot of inventors, they file patents for other reasons. For example, freedom to operate. And I don't mean the same meaning the freedom to operate. I mean, actually be able to practice something without infringing anybody else's patent. So when you file something, you can say, okay, this is my field and I'm going to research here. Like, let's say if you're a pharmaceutical company, I patented this composition, so I want to make sure no one else is patenting it. So when I create it, when I experiment with it, when I play around with it to do my research, I'm no longer at risk of infringing anyone's patent. That's one reason. A lot of software companies, a lot of early startups, they use patents to leverage patents in negotiation, and especially to raise funds. One of the best ways to show that you're an innovative company is to show that you have patents or you have a big family of patents, because it's an important, and I think this is a great segue to talk about vaporware. A lot of patents, a lot of companies that they say they do certain things, but they don't actually do that thing, or they're embellishing, or even I would say over-exaggerating the results of what they do. Well, you can fool investors on a website. I can just say right now, I have a quantum AI combined approach that Ari and I just invented. Create a website called Kamyar, and go to the investors. But it's going to be hard because the patent office. It's harder to fool them, and the patent becomes public, and that's basically in every single jurisdiction that I know of. Really, unless you have a state secret, like you invented a new rocket or something, and the United States government doesn't want you to publish it, everything else is going to be in the public domain. So your competitors can read it. They're going to know exactly, because your competitors they know that field, right? So they're going to know what you actually have and what you don't have. So a lot of people, to go back to Ali's question, a lot of people, they file patents to show, hey, we actually have these innovations and we want to raise, X amount of money, and we can show you our innovation. We can show you that we're actually working on the R&D. So I would say at early stage, it's probably better. Of course, there's no one size fits all. If you discovered the new Coke formula, you should keep it as a trade secret. But you should probably assume that your invention is not the best thing ever, and you should not assume that others are not working on the same thing. So I would suggest maybe filing a patent application. Now, in US at least, you can file a patent application and you can request it not to be published until it's issued, which is a long process. So if you want to keep it a secret, and nobody will ever see it before it issues, which is maybe 2-3 years down the road. So if you really want to keep it a secret, and we do this for clients regularly, you can file it and you can request a non-publication. And that way your competitors are not actually seeing in real time what you're doing. But patents are much better than trade secrets, especially for early startups. It's going to be hard to go to a VC or try to raise funds by saying, hey, we have this AI model and it's a super secret and we're not going to tell you anything about it, but I want you to give me $5 million to go ahead and start my company, but I can't tell you anything about it.
We have also a comment by Ali. I will let Kamyar to read it offline. We have a question by Arsalan. I will read your question, Arsalan, but just to follow up what Ali said. Most of the time we have in mind that patent is an offensive weapon, for forbidding others to do our stuff, or to just like monopoly, being in position to take money from licensing out. But it also has a defensive, let's say, virtue, that when you have the patent, a competitor, even if he sue you, you can continue to exploit your invention. But if you don't have the patent, if a competitor sue you, you have to stop at the moment you receive the lawyer's notification.
Yeah, right. Yeah. That's the freedom I was talking about. If you're trying to be in that space, look, we live realistically. If you're in tech, if you're in deep tech, there's so many other players out there, and if you're not protecting your innovation, someone's gonna grab it, and not on purpose. No one's monitoring what you're doing. Maybe some are, but no one's trying to protect it. No one's trying to steal your ideas. But let's say you're using AI for, drug discovery. You're not the only company out there who's doing that. There's a lot of other people, and we're all part of the scientific community, right? So they might come up with the same thing as you did, maybe a couple of weeks after. In the old times, at least in the US, there was a way to say, hey, we came up with the invention first, even though we did not file a patent, so you could backdate it. AIA, which is the American Invent Act, I don't even know when it was enacted. It was so long ago that the previous law is not applicable for most cases. Said, which is now what is the law in Europe and in most countries, is whoever files the patent application first is the people who will get it, unless there's fraud or wrongdoing, like I hacked into your system and stole it. Absent that caveat, if you and I come up with the same invention and I have it, and we both have it, and I file it tomorrow, I can sue you even though you independently came up with it. So highly recommend, Ali, if there's something, that you or any of your clients have, to talk to a patent attorney. Probably a good idea.
Arsalan asked us, what have you learned about client communication with your years of experience, tips, pitfall, managing expectations?
So I do a lot of software and software AI, and I'm trying to get into quantum computing. And protecting software innovation is a little bit more challenging than tangible, old school, I just invented a hammer or drill or whatever. I think the most important thing is to provide enough information to the client so they make an informed decision. To tell them this is not an easy process. It's an easy process. It's not necessarily a timely process. Unless you're spending a lot of money, the patent office has a big backlog. Right now in software space, I think it's about 18 months. So it's not 18 months for you to get the patent. It's 18 months for somebody at the patent office. This is US. To pick up your application and start reviewing, because the backlog, especially now with AI, it's just so many people are filing so many patent applications. There is the patent eligibility idea. So in software, this is really specific to software. AI algorithms, they often struggle with the abstract idea exclusion. Some people see them as mathematical or an abstract rather than technical invention. There's in the US and in Europe, there's a concept that you cannot patent a law of nature. And that's good for policy because you don't want people to patent math. E equals MC squared can never be patented because it's right. So it's a representation of a law of nature. However amazing that discovery was, you cannot patent that. You cannot patent. There was a big relevant case about genes, and I know that's not my area of expertise, but you cannot patent that gene. You can do the synthetic, and there are other ways of doing it, but you cannot, because the gene actually occurs naturally. So the best thing that I have learned is to provide enough information so they make an informed decision.
I have a great, let's say, meme to show.
Okay, I love those.
That illustrate perfectly the difference between a scientific discovery and an invention. So just let me share my screen. Hope everybody will see it. So for those who are just listening and not watching the screen, we see an Egyptian pyramid, and the subtitle is "How were the pyramid built?" And someone just posted the comment, well, the pyramids were built before Isaac Newton invented gravity, so the stone's weight wasn't a problem.
That is 100% how it worked.
So it's a great thing because it's really show what the difference between what is a scientific discovery and what is a technical invention. Fantastic. I think we have a full picture of what IP is and what it can do for inventors. Now let's dig in a little bit into. You started talking about that, but maybe you can dig a little bit about this emerging field that is artificial intelligence. How is it challenging for you, patent lawyers, IP lawyers, to decipher exactly what artificial intelligence is or is not patentable or is not patentable or even protectable by other means, just as you said at the beginning of your talk.
Sure. I just had a chair malfunction.
I had that problem many times also. You have to find a solution for that.
Right, absolutely. Speaking of memes, I saw this meme and it said, sell this patent. And it's a big, I don't know if you've ever seen Wolf of Wall Street. There's a scene that says, sell this pen. And the second part of the meme says, this is an AI-enabled pen. So I feel like AI is everywhere now. I traveled to San Francisco for work and for personal reasons because my family lived there quite a bit, twice in the last month. And it's funny because you pass Bay Bridge and you get into San Francisco and there are all these billboards. And I wish I could do some sort of a time series, like compare from the same viewpoint, compare what the billboards say, throughout the time, there was a time that they all said, allow us to do better queries for you. Then blockchain became a thing, quote unquote. Every billboard, the power of blockchain enables us to do this and that, this. And now, as in 2 weeks ago, I was there, everything is AI, just AI billboard. So AI is everywhere. I think before we discuss what it is that we need to protect, I think there's an important thing to note that most people mean machine learning when they say AI. AI can really be anything that is artificial intelligence, right? So a simple regression model. And when I say simple, I don't want to oversimplify that. It's not simple, but compared to machine learning, it's now simple. There was a time that was the top invention. A regression model can also be AI. Really, anything that mimics, intelligence or decision making can be AI. Most people now, they mean machine learning when they say AI. It has become very ubiquitous, which is a great thing. But also it's very clear that a lot of people are kind of sort of just putting that out there. I was listening to somebody talk about this, so I don't want to take credit for it. I forgot who it was, but they're saying AI now, it's very similar or at least analogous to where internet was in the early 2000s, where two things existed at the same time. It was very clear that internet and internet technology, network, was going to be a big part of our lives. But it was also very clear that there was going to be a bubble, and a lot of people were just saying it so they can get funded. But so both of those things are accurate, and they can exist at the same time. AI is very real. It's very helpful. It can be harnessed to humanity's advantage, and it has been, and it's going to continue. But at the same time, there's a lot of people who are going to just add AI to whatever they want so they can get funding, they can get more attention from VCs. Both of those things are real. Now, you asked about protection of AI. So I've been doing this for about 10 years. So I've been patenting a lot of data science innovations and AI innovations for about 10 years. And I personally put everything in 3 buckets, 3 categories.
Sorry, I interrupt you because I want to add a question for your answer. Do you consider what happens? No. Do you consider the intellectual property around IP this exactly the same thing that was for old school algorithm and software, or have you been little bit forced to reinvent your approach?
Oh, absolutely. That's a great question. So the Patent Office in US, they've created a new task force just so they can give us more examples of what is patent eligible when it comes to AI. So this is definitely something that they're thinking about. I know European office the same way. So it's not being protected the same way as before, because AI is fundamentally different. But because it's fundamentally different, a lot of people can kind of use it as a black box, right? So it is a little bit different. AI products can be put into 3 categories. And the first one is something that actually addresses a technical issue that exists in AI. If you came up with a new training paradigm, if you came up, like the people who came up with the idea of transformer, the T in GP, the people who tokenize things differently, the people who cluster things differently, those are very nuanced, very specific AI technology innovations, and they can be protected because both in the US and in Europe and pretty much everywhere in the world, they view that as improving AI, as pure technology speak. Then there's a second bucket, and that's really a limited number of people who care about that kind of stuff. There's a very limited people who push the boundaries of what AI can do. So it's a very small bucket, but nevertheless, it exists. That's really the kind of people who come up with these, the first people who came up with deep learning. First groups, definitely not an individual endeavor. That type of technology can be protected because it, creates a technical improvement. You can train it faster. You can get better results. So that's the first bucket. The second bucket, which is most, I would say a lot more, maybe not most, but a lot more innovations come out of this bucket, is they use existing AI or even come up with their own or train their own models to really solve a business problem or solve a problem. So I don't want to give an example because then I don't want to disparage anybody or any
No,
company.
no, we totally understand because, and it's a great business field because you have,
Yeah,
I call them the vertical business of AI because they have a pocket of data very specialized for a
yeah,
specific industry or business, and they train their model on this subtype of data,
exactly.
and they are fantastic business.
Exactly. And it's interesting because I think ironically the financial industry, the hedge funds and the traders, they picked up on that a lot earlier than some of the scientific community. So 2015, 16, 17, a lot of our clients were financial industry people who said, we have all this data. So how can we harness AI to figure out what's going on? Now, there are a lot of people, at least in my universe, are biotech people. They have bio data. How can we figure out what's going on here? We have this data that we can train specific, and that's a little bit more challenging to protect, even though it's not impossible, because there was a time that you could say, I'm going to apply this data, and I'm going to train a machine learning model, and it's going to give me a result. And that is an example of something that's not necessarily patent eligible on its own. So we have to work harder to figure out, okay, is there something special that you do with AI? Do you train it differently? What do other people do? Why is your way better than the other conventional methods of things? So that's the second bucket. And then the third bucket is a lot of people who use existing models, and they have great products. And they save a lot of money for a lot of entities, a lot of companies. It's just that it's very hard to protect it because it's really an off-the-shelf model that is applied to certain problem to give a generic solution. So I think it's important for anybody who's listening to bifurcate whether something is profitable or even helpful for an entity versus something that can be protected and patented at least.
Fantastic. Just we moved on the next subject. I just want to share once again my screen.
Yeah.
Something. Just give me 1 second. Voila, it's here. No, I make a mistake. This one. Okay, I found this infographics on this illustration on the LinkedIn profile of Miss Sol Rashidi, which is who is one of the leading AI experts at Amazon, and she was just she wanted to show us that ChatGTP and other competitors such as Claude, Mistral, and so on are just the visible part of the iceberg, and all of these guys are doing artificial intelligence. So I won't read them, but we have all the natural language processing system, you have the computer vision, the machine learning, and all of these guys have subtype of. So that's how, this illustration shows how much this field is emulating. It's dynamic and complex to understand.
Oh yeah, that's fantastic. By the way, that's a great chart. Yes, it's funny. I think I was telling you before we started the podcast. When I was at IBM. This makes me feel really old. IBM came to us or to everybody at work and said, we're going to open up our NLP model, which was language model before LLM. We're going to open up our NLP model. And if you sign up, you'll get 15 minutes for free to play around, do whatever you want with our language model. And then 15 minutes for free to put in whatever information you want. And that was a predictive thing. So, for example, I once put in all my transactions for my credit card. I said, can you figure out a pattern? It basically did not find any pattern, and it just said you just eat out too much and you go out too much. But it was 15 minutes of free language model, and I could not. And I told all my friends. I told my dad, who's also an engineer. I couldn't get a single person to try even the language model of IBM. Every single one of them are now using GPT. They're super happy about it. They're impressed. There was a time that I would just say, this is a language model. And they're like, chatbots existed. I'm like, that's not really a chatbot. It's fundamentally different. And they're like, nah, it's a computer. And all those people are converts now. So AI has definitely become, in a way that I'm really happy, very ubiquitous. And there's a lot more, as you showed, there's a lot more for us to as humanity to explore. The power of AI, now with a lot of health tech or tech health, however you want to say it, companies exploring different aspects of AI. I think it can certainly apply to a lot more than the way we're using AI today. I think in 10 years we'll look back. If if I'm around, we'll look back and talk about this podcast and say, "Wow, we did not know what else we could do with AI."
And in terms of ethics and law, there are many fields that this AI, but also robotics, will how can I say that, are opening just for writing articles. I read, like most people, I use it a lot. The content produced by ChatGPT and its competitor Mistral and Claude and whatever, the Perplexity, etc. Who is the owner of the article written by the AI? Is it Sam Altman? Is it me, or is it the model? Or is it the content that that the LLM has stolen? This is do you have some progress in United States about the regulation or not
There
yet?
is not yet. And to add something even to your question, that's even more complicated and unknown. ChatGPT or all these models, there are data hungry. AI is very data hungry. So the more data you can bring in, the better. So if you're a company like Tesla, you want to train your model, you can monitor how people drive or make videos and stuff, and then your model ingests that as training. So it learns what to do when the light turns red or green, right? A lot of these LLMs, well, they need text. So where do you get text? Well, you get it from a lot of books and stuff. So I think there's a bunch of celebrities suing ChatGPT or in half suit, saying, hey, you know what? I wrote a book and I have the copyright to it. So I don't want you to use this to train your model because I own that content. Now, I really don't know. I keep going back and forth on it because if you think of AI as, like, let's say a child, you're training a person, right? You're training a model to do something. Well, it should be able to ingest things in the public domain, or it can even learn from. It's not. I can see how if it copied and pasted your book or your copyrighted material,
Is that bad?
and I see a friend who's a big Disney fan on this podcast listening in now. If it ingested Mickey Mouse and gave you exactly Mickey Mouse, I can see how that's a problem. But to learn how Mickey Mouse looked like and then draw you something entirely different, I don't think that's the same. But I also see the other side of that argument as well.
It's like the singing word. You have someone who has a good talent, to sing, have good voice, and he's completely fan of, let's say, Lady Gaga, and she trained to sing just like Lady Gaga, but
Yeah.
Lady Gaga can't sue her. It's just her natural voice. And ChatGPT, if I ask ChatGPT to write me a chapter just like Tolkien, or
Yeah.
or the author of any other famous books, he will write me something with the style of Tolkien, but it's not Tolkien.
Yeah. No, absolutely. It's remained to be seen what will happen. I mean, the models are not going anywhere, right? I think as society, we're seeing the value in AI and how much it can help. So I don't think the models are going to go anywhere. It's just a matter of, like, who can use what to train what model.
Ali asked, have you worked with the standardization and NEST? I don't know what is this.
NEST. I have not.
Okay. We are running.
Oh, yeah.
We are running a little bit out of time, so maybe we can end this great conversation. Another crazy technological revolution is quantum technology. By the way, quantum technology already exists since Einstein. We are at the third revolution in the quantum technology. We have all the electronical chips we have in our hardware use quantum physics, quantum mechanics, to make for the chips. But now we are at the third revolution in the quantum technology with the quantum computing, which there is also the hardware, the software, but also the algorithm. I had a great PhD student who worked on the algorithm of quantum. It's a crazy work. What is your thought about these emerging fields?
So that's quickly become my favorite thing to talk about and research and try to get into. Absolutely, quantum existed. At some point, Einstein, maybe even a little bit before that, people found out that conventional physics is conventional physics, and then there is at an atomic level things behave a little bit differently. And now we're just starting to be able to harness that power to our advantage in a way that can be shipped out to the public, in a way that's a computer that someone like me can just sit down and use, right? So, scientific community knew about it, but it's hard to bring that to mass population. So just a quick description for some of the people listening. So, there's the conventional computers, and they use chips, and there's the 0 and 1, and then there is the quantum computers. And the difference is, for whatever reason, and maybe you can explain it, I've read it multiple times, I still don't necessarily understand it. I've taken classes. I pretend like I know, but I still don't really know. But at the quantum level, something can exist in a 0 and 1, obviously, but it can also exist in a superposition, which is 0 and 1 at the same time, simultaneous. And that really opens up a big avenue for us to do some parallel work, to use that for increasing the computing power. So I was reading this very interesting book called Quantum Supremacy. I forgot the author's name. He's a very famous Japanese-American physicist. I can't believe I forgot his name, but a very famous one. And he gave this very interesting analogy. So when you have a conventional computer, when you have a conventional chip, you have a thumbs up, 1, thumbs down, 0. And you're limited to up and down. But with quantum, you can really use all the angles in between. So imagine if instead of up and down, you had all the angles in between. So that's the power of quantum computing. By the way, quantum supremacy really is a concept that they came up with. The fact that at some point quantum surpassed supercomputer and all the computers put together. So something, I think Google at some point, they put together a quantum computer that could do something that would take conventional computers hundreds of years to do in minutes. Quantum computing technology really is based on that binary versus non, I don't want to say non-binary, but the new paradigm. And instead of chips, they have Q-chip. Instead of bits, they have qubits. That can be 0, 1, or 0 and 1. Now we're really in the early stages of quantum and how to harness, because it's not easy to actually implement this in real life, to get a computer. Qubits, the technology, ion trapping, which a lot of people are using, works. But it's really hard and it's very expensive right now. I think last I heard, one single quantum computer can cost a little bit more than $1 million, and that's the minimal one. For qubits to work, ion trapping to work, you need extremely low temperature. So because this is with electrons and counter electrons, so you need the area to be completely isolated from photons coming in, from any heat coming in. So just to keep that cold, it's going to cost a lot of money. To keep it cold, it's going to be very noisy. You need a huge computer to actually make that work. So there are definitely challenges, but the technology is real. And there are companies like IBM, like Google, they have made that work, and we actually do have working quantum computers now. Very ironically, the way IBM allowed you to use 15 minutes of AI in 2014, now they're using the same example. They're allowing people to play around for 15 minutes for free a month with their quantum computer. So if you're listening to this, feel free to sign up and you can play around with it. I do have to warn you, there's not much that you will ever do that needs a quantum computer. right? Like in our daily lives, there's not much we do. I mean, unless you're modeling proteins or modeling nature or, serious stuff, you don't need that type of vast computer, which brings me to the second point. I think in the future, quantum computers can be used as complementary to conventional. At conferences, people talk about Q chips, which is a quantum chip that is used at the same time as conventional chips. So you can use some stuff, you can calculate certain things with a quantum chip and the rest of it conventional chip.
Absolutely. Maybe just a last word about, as you have the site position on the IP world. Do you have some numbers about the patent number in quantum? Is there something that you see booming, or is it stable?
Yeah, and that's the interesting part to me, because when you look at technology, scientific community, that's usually typical. Scientific community knows about it, and it's just scientists and nerds talking about it. Then they write publications, they try to patent that idea. Then comes the money, and then it hits mainstream, and a lot of people then know about it. You think about where AI is now, or any really GPS, any other computing technology. There was a lot of people in the scientific community. Then you saw a lot of papers being published. Then you saw a lot of patents or other intellectual property being protected. Then money went into startups. And then you saw people, then the general public then just knew about it. ChatGPT, AI was not invented 2 years ago when ChatGPT went public, right? Yeah, right. It was a long time before that. So I was digging around, just looking into some numbers. In 2022, I think there was about 5,000 patents.
5,000 patents on quantum tech. Wow.
On quantum tech, and that's
applied to quantum computing, not because
quantum computing.
Quantum computing,
all hardware, software, all quantum. And now it's about 16 actually. Wow. So there's a big increase. 2 years, big increase. 16,000.
16,000 patents.
Yeah. Wow. So that's a big. And then you look at the money. McKinsey published a paper in April, and I know we're now almost end of October now. So April seems. For tech, that's a long time ago, but that's the latest numbers that McKinsey actually looks at these numbers, and the numbers for tech, for quantum tech, is really increasing. I think globally there was about a $42 billion investment. Most of it is actually for China. China had about 16 billion. US had about 5 billion, which is significantly lower than China, and then all other countries had the rest of it. So I think year over year is about 30% increase in just the money that goes to startups so they can play around with this technology and figure out what is good and what can be done. Most of the money right now is from, at least in the United States, is from the US government, places like DOD and other government entities that go to startups. One interesting thing about quantum is that it will change many things. One of the things that it's been mathematically proven to change is cryptography, because right now most encryptions are based on RSA token or all these encryption, and it's not impossible to break those. It's impossible to do them in a timely manner. So it'll take hundreds of years for you to break that key because there's so many primary numbers. Quantum can do that in minutes, if not faster. So one thing that will for sure change is cryptography, electronic messaging, and I think the U.S. government has got the memo that they need to get ahead of this before somebody else does. So they're pouring a lot of money into cybersecurity and cryptography.
Just imagine the day the real quantum computing will be announced. We have a definitive one that works, etc. That day, all the crypto will fall down, just like the card castle. Boom.
Yeah. It's gonna make right. It's gonna, like, I feel like in about 50, 100 years, or whenever this is possible, they're gonna look back at our encryption, the way we look back at like pigeons carrying, messages, and they're like, wow, you guys just texted whatever you wanted on your cell phone. You just put in your password on your phone. Like, I don't understand. Yeah, it's going to be generations of people looking back at us thinking you guys were crazy. But yeah, that's I think the biggest use case that can be justified for quantum is that, even though there are many other use cases for quantum. I think it's going to change healthcare for sure.
Absolutely.
I think it's going to change cybersecurity. We talked about it's going to be a very good complementary processing power for AI, actually. Right now, I read somewhere that every query on ChatGPT takes 5 to 20 times more power than Google regular search does. I think Microsoft just bought something like a nuclear power plant just so they can power their AI models. Quantum will help train models a lot faster. It can help accelerate execution of models. Future is bright.
It's crazy because you talk about the nuclear plant. I didn't know that we can hire or buy tiny nuclear plant for private use. That was crazy. I didn't know that it exists. Before this anecdote. We have a last question by Ali, and I will show it. Which platform today are closest to having AGI, artificial general intelligence, ready data?
General. I like ChatGPT. I don't think anyone is even close to having general intelligence. But ChatGPT obviously has a great LLM model. They also have deep learning. They also have an app that can run on your computer, on your cell phone. They have used it. It's not that they have invented or came up with something that other tech companies did not know. They just figured out a way to make it very easily accessible to everybody. You can literally. I was in Europe not too long ago, and I was able to just say, hey, I'm going to say stuff in English, and I want you to translate that to French. And then when that person responds to me, also listen in and then translate that back to English form. And I typed nothing, and I just said that, and it worked perfect. So that is something that other companies have not figured out yet. I think that's the best value for them. But they're not far off behind. General intelligence, I think we're not close to that yet.
You talk about a great book, so I share the screen, Quantum Supremacy,
yes,
by Michio Kaku, who is a great physician.
Yep.
So
Yes.
of course, I will share the link on the blog article, but now you have it on screen, so you can.
Yeah. We also have at Foley a few colleagues and I write a blog called Beyond the Binary. So if you Google Beyond the Binary, Foley and Lardner, we talk about quantum and at a high level, so nothing technical, because then people will get bored and would stop listening or stop reading, I should say. We talk about the transcendency of quantum, how it can be protected, how it can be harnessed. I see a lot of. I feel like quantum now is kind of like AI in early 2010.
I will, of course, share the link of the blog so people can take a look. Kamyar, it was a great pleasure to have you. The talk was very cool. Thank you very much.
Thank you. Thank you for having me.
You popularize a very technical field because it's important, and you do it perfectly. Because once again, it's very important for scientists, engineers to be interested by this field, that is IP, intellectual property. Just as an anecdote, in France, where I performed my PhD studies, the principal investigator, the people who led the lab, usually the professors keep PhD students away from intellectual property. They prefer us to stay in the ignorant state because, and it's true, because they want to stall us.
Yeah.
They want to steal us our discovery. So if I have one advice to PhD students, interest yourself to IP. Just buy a book, read it by yourself, and then connect with people like Kamyar, who can then drive you to the great way. Thank you so much.
Thank you. Thank you for